In the Karen Reed trial, there are several issues that, if they go one way or the other, decide the case. They absolutely decide the case. That's all I would need to know. That's all that any juror would need to know. Certain issues, certain facts that are in dispute. If they go one way or the other, it's game over. There's nothing else to talk about. And this issue that I'm going to talk about in this video, planted evidence, is one of them. This is one of them. The only way I believe that you can claim Karen Reed is not guilty of everything, right? Remember, there's the top charge, there's lesser included that include accidental behavior. But the only way she is cleared of everything is if the evidence is planted at the scene. Period. Full stop. End of story. So for you to believe that she's not guilty of everything, you need to believe that the evidence was planted. And that is clear. That is absolutely clear in this case. I'm going to walk through it. I'm going to explain why, and we're going to talk about whether or not this evidence could have been planted. Was there an opportunity to do it? Who could have done it? When could they have done it? It's a huge issue, but it's one of those issues that's dispositive of this case. If you believe, or if you don't believe the evidence is planted, there's no way that you as a juror can vote not guilty. I'll explain. I'm Vinnie, lead anchor for Court TV. I am live on television delivering 2 hours of true crime Monday through Friday, 8 p.m. to 10 p.m. every day of the week. Monday, Tuesday, Wednesday, Thursday, and Friday on Court TV. In between, when I can, I'm live streaming, and that's what you're watching now. This is Vinnie Live.
Hey, get ready, get set, let's go.
It's true crime, streaming live, worldwide. It's Vinnie Live. It's true crime, streaming live, worldwide. It's Vinnie Live. Get ready. So post inside the chat. Get ready for the prosecutor hat. Get set to like and to subscribe. Let's go. It's time for Vinnie Live.
It's amazing when you're in the middle of a case like this, when you are all in, every witness, every moment, every piece of evidence, and it becomes your life. It becomes your life. I mean, from my perspective, I'm at the doctor's today. And maybe, you're probably going through the same thing I am, right? I'm at the doctor, so I got to bring my phone with me. And I'm in the waiting room. I'm watching the trial. You wait a while. They bring you into the little office, and then the nurse comes in. The nurse leaves, and then you're there. Boop, back on the trial. Oh, the doctor's here. Okay. What's, how's my A1C? How's everything else going? Okay. Thanks, doc. See you later. Back to here. Get in the car, plug it in, listen to it while you're driving. All right, time to figure out what I'm eating for lunch after the doctor's appointment. Oh, I'm going to stop by Publix, pick up some stuff, go into Publix, put the phone right in the shopping cart, put the volume up because I'm not using headphones, and I'm just watching the trial, going from aisle to aisle. Oh, there's some nice arugula. Oh, those eggs. Let me see. Are any of them cracked? Nope, not cracked. Or I'll take those eggs. All right, over to the fruit aisle. Oh, I'll get that really expensive cut fruit that they make. All right. Oh, that's good. It doesn't look like it's $14 worth of fruit, but I'll take it. All right, go to the checkout. I'm in the line, getting ready to check out still. The trial's going. It's going. And then, that's your life, right? That's my life. And then, I've got to prepare for the show. So we have to have a meeting. So while we're having the meeting, we can't watch the trial. So we're having the meeting and we're like trying to get through it. You finish the meeting, boom, you get back to the trial. You're watching. You fast forward through the sidebars. Thank goodness the sidebars and the morning break and the lunch break, because then you can fast forward through them and catch up. And then today I just happened to be caught up to everything. And I'm like, okay, let's live stream. And what I want to live stream about is this issue, because this is, again, folks are alleging, overwhelmingly the viewership of Court TV and, all these channels. Anytime I put up a survey or whatever, I think it's about 80-20, 75-25, depending upon the day. That's the split. And the larger number is for not guilty for Karen Read in this case. That's just the way it is. That's the reality of it. It's not quite to the level of Johnny Depp, but pretty close to Johnny Depp. Johnny Depp, the audience was overwhelmingly for Johnny Depp versus Amber Heard. And guess what? At the end of the day, the jury was in sync with the public. So I'm wondering in this case if it's going to be the same thing. Will the jury be in sync with the public? The difference is the public watched the first trial too. At least a lot of them did. So they have a little bit of a different vantage point than the jury this time around. But still, that's a problem. But then you dive into it and you get into everything. Like last night on my show on Vinnie Investigates, I did a scroll of all the people, and I don't think it was everyone, but it was, it was like 20 different names that I had that had in one way or another been implicated as part of the conspiracy / cover-up, right? Because there's a lot to this. There's what happened to John O'Keefe. That's part, to me, of the conspiracy. And then there are some of the people who, after the fact, like the state troopers, et cetera, who've been accused of part of the cover-up of the actual crime, and then the implication of someone else. That's another part of the conspiracy. The conspiracy is what happened to John O'Keefe. The conspiracy is framing Karen Read. And then the cover-up is, all of it after the fact. So you put that together, I had at least 20 people named as part of that conspiracy / cover-up. And I think I could add a few more as well. And that's based upon the cross-examination, what we've heard in motions, what we've seen in court papers, and what has actually been said, and the accusations that have been made public in all of this. Now, the jury may not hear all of what I heard, but I was going by everything that we've heard in front of the jury, outside the presence of the jury, on the courthouse steps, wherever, right? Who is part of this alleged conspiracy cover-up? And the number is at least 20 people. And perhaps more. Okay. So in a case like this, where it's overwhelming, people believe not guilty, not guilty, not guilty, there are certain facts or evidence that would contradict that. Okay. And one is the evidence that's found at the scene. So let's start going through that. And today was a day where we saw some of this evidence at the scene, some of the pictures. For instance, John O'Keefe's shoe, right? He's found with one shoe on, one shoe off. This shoe is found here by the curb and the street. Okay. Now, this evidence had to be planted. For Karen Read to be not guilty, this evidence had to be planted. Why do I say that? Well, because it's his shoe and it's in the street and it's underneath the snow. Right? They dug it out from underneath the snow. So someone would have had to have put it there, which is planting evidence. From the prosecution perspective, in cases where a pedestrian's been struck by a vehicle, one of the common denominators in a lot of those cases, not all of them, but it is very common for the victim who's been struck by a vehicle to not have their shoes on. In this case, he had one shoe on, one shoe off. So that's what prosecutors will argue, is that's how it came off on impact. And that would tell us where he was standing at the time. That's what they're going to say. For Karen Read to be not guilty, that shoe needs to be planted there. So the question is, who did it and when did they do it? Okay, because this is a different piece of evidence. We're not talking about taillight right now. We'll get to that in a second. We're talking about the shoe. So who put the shoe there and when did they put it there? Because if something happened to him in the house, is that when it was done? Because that would be planting evidence too, right? You drag the body out and you say, okay, let's take off a shoe and put it in the street because we are law enforcement. We know that when someone's struck by a vehicle, often their shoe comes off. So I think in this case, you would have to argue that it's someone in the house, whoever is allegedly placing the body on the front yard, would have to think to remove the shoe and place it in the curb and continue to allow the snow to fall on top of it. Now, is there any evidence of that? No. Can you make a reasonable inference of that? Maybe, maybe not. Maybe, maybe not. I think this is a tough piece of evidence for the defense. I really do. Like, I understand we're going to get to it. I understand the theory behind the taillight, and I know all the controversy, but this is not the taillight. This is the victim's shoe, not on his foot, not on his body, separated, kind of where the curb meets the road. Which, again, I've covered cases for years and years and years, including the case down in South Carolina, Stephen Smith, who was struck by a car. One of the things that came out there is that it is very common for the victim to not have their shoes on if they've been struck by a car. It's not in every case. Obviously, it's not in every case. There are exceptions. But this is consistent with that. So for Karen Reed to have not struck John O'Keefe, this would have to be planted, or in the alternative, John O'Keefe would have had to been struck by somebody else. Right? Struck by somebody else. I don't know if we have evidence of that. Or whoever placed the body would have had to have thought to take off the shoe and plant it there. When did they do that? I believe, because I remember from the first trial, it was dug out from underneath the snow, that it would have had to have been placed there prior to the morning, prior to the discovery of John O'Keefe. Because the shoe was missing. They knew the shoe was missing. And you can look at the images of John O'Keefe. There's a shoe missing. So if there's a shoe missing, this is the shoe. It's in the street, right up against the curb. What's the reasonable inference from that? What's the reasonable inference from that? Big piece of evidence. So for a complete not guilty on everything, right, including the lesser included charges, you'd have to believe that the shoe was planted there. And I'd argue you'd have to, and here's another shot of it as well. You could take another shot, take a look, and you could see how in this shot there was more snow packed on top of it before it was dug out, right? Over here, it's more uncovered. Here, oops, where is it? Here, it's more covered with snow. So they're digging it out and they found it. Important piece of evidence. This is not a small piece of evidence. This is an important piece of evidence that the defense needs to establish in some way that someone had opportunity to plant it. Have to address it. You can't just leave it there. Because today, inside the courtroom, the jury got to see it. Obviously, it's dried up now. But they brought it into court. They brought it into court. This is an issue that they have to win. The defense has to win this. They have to convince the jury. They don't have to convince them beyond a reasonable doubt. What they need to do really is just raise the specter that it's reasonable to believe that it's possible that this evidence was planted. They don't have to prove that it was planted, like prosecutors have to prove their case. But the defense in the raising of reasonable doubt area where they live just has to make it into a reasonable argument. Is it reasonable to believe that someone would have taken off John O'Keefe's shoe and placed it on the curb? So what that tells me is, from the beginning of this alleged conspiracy, again, trying to understand the conspiracy, from the beginning, they knew that they were going with John O'Keefe got struck by a car. Now, were they always going to say he was struck by Karen Reed, or did Karen Reed put herself in the middle of that? Were they going to say it was the snow plow that hit him? I don't know. I don't know. But at a minimum, because of where, and again, this is presuming or putting myself into the shoes, pun intended, of the defense of this conspiracy and cover-up. Right out of the gate, the cover-up and conspiracy has to include the notion that John O'Keefe was struck by a vehicle. That's the only reason you would take the shoe off. Being a member of law enforcement, you may very well know that. Having come across cases where pedestrians have been struck in the past, and you come by, oh yeah, they're missing a shoe. We've seen this before. Right? It's not a mystery. Like, people know that. People who've investigated pedestrian accidents know that oftentimes, not every time, but oftentimes, the pedestrian will lose a shoe or their shoes will come off on impact. So that's why this is such a big deal. That's why this is such a big deal. So now, again, looking at what they're trying to do, they've got to convince this jury that it's reasonable to believe that someone planted that shoe. So when would they have planted it? It's not the next morning, because the shoe is buried under the snow. You can argue it's the next morning, but when do they get the shoe? Like, who has the shoe? Did the shoe come off in the house? If the shoe came off in the house, then when did they get it from the house to the curb? If the shoe was on him and then the person planting it actually took it off of John O'Keefe, then it would have been when they placed his body on the front yard. I don't see a scenario where it could have been planted by Proctor or any member of the state police. Because, like, when did they get the shoe? When did they put it under the snow? Is the question. So that's why they need to win this. They need to win this issue, which is not prove it beyond a reasonable doubt, but convince the jury that it's reasonable to believe that someone in the house planted the shoe at the curb. Most likely someone in law enforcement who has seen a pedestrian vehicle accident or accidents through the years and understands that happens a lot. And a lot of times the victims, after they're struck, are found without one or two shoes. All right. I'm keeping my eye on the chat room. Don't you worry, folks. Don't you fret.
To get happy, it's time to get funky. It's time for us to smile, 'cause here comes McSpunky.
Of all the cases that we cover, this is probably one where we need McSpunky the most because of the way everyone is taking all this very personal, everyone is very invested in their perspective on the case, and they don't want to hear it from the other side. And they get very nasty, which is why we bring in McSpunky to put a smile on our faces for a second and give us the perspective. Hey, St. Vincenzo, Gen X, Frankie Figs, and blessings to all y'all. Thank you, Nick Spunky. Always appreciated. All right, let's get back to the evidence. Where is it? Here we go. Back to the evidence. All right, let's move on from the shoe, which is huge. It's huge. Red tail light. Okay. This one I think we all know a little bit more about. And this one I've debated on my show plenty of times and looked at a lot of images on my show and on my live streams. We're not going to go through all those images of the taillight today, but we're going to talk about the red taillight that is found at the scene close to where John O'Keefe's body was found. The jury must, for Karen Reed to walk away. I'm not saying hung jury, but to walk away, not lesser included, but to walk away from this case with 3 not guilty verdicts on the 3 counts. The jury needs to believe that it's reasonable that someone planted the tail light at the scene. They have to. Because if they don't, there's no other reasonable explanation for that tail light being there. Okay? Someone had to plant it, or she struck John O'Keefe. Those are the only 2 conclusions, which is why this issue is so dispositive, right? Either she struck him and the tail light exploded, imploded, and we can debate that on another day. But that's the prosecution theory. The taillight was impacted. The taillight was broken at the scene where John O'Keefe was struck by the SUV, or the evidence, the taillight, was planted at the scene. Those are the only 2 choices. I don't know of another choice. Do you know of another choice? I don't know of one. Because it's clear from the testimony that the taillight was found there. And I have to ask you another question about that. When the taillight was found, the people finding it, are they part of the conspiracy, or are they being duped? Are they part of the conspiracy, those who are finding pieces of taillight, or are they being duped by those who are part of the conspiracy and are planting the evidence at the scene? Now, it's chaotic. It's dark. There's 2 feet of snow on the ground. There's a lot of things going on at this scene at the time that the taillight is being recovered. The pieces are being recovered. All right, we've got a comment from Dr. Jen N. The medical experts may also be helpful this time around. The autopsy showed an abrasion above his laceration on the head, so likely impact from higher up, likely from a blunt object, not a car, says Dr. Jen N. All those witnesses are significant, important, etc. But I would argue, Dr. Jen N., this is crucial. Okay, this doesn't come down to experts. This comes down to common sense. And thank you so much, Dr. Jen Ann. Appreciate it. This comes down to common sense. The jury doesn't need an expert to talk about this. The jury say broken taillight on Karen Reed's car, taillight pieces found at the scene where John O'Keefe is found. 2 + 2 = 4. Unless the taillight pieces were planted there. You see, that's it. If they're not planted there, you're not walking home. Now, it could be something less than the top count. That's, again, another discussion for another day. But I'm talking about not guilty, victim of conspiracy, victim of cover-up. This is a huge part of it. This tail light, every fragment of that tail light needed to be planted at the scene. Period. And the only question I have about that I'm not clear about is, do they believe that those who are finding taillight pieces and recovering them at the scene are in on it, are being duped, or are just turning a blind eye? Because there's a bunch of folks there. You got the CERT team there. You've got a lot of folks who are searching there at night. Do they not see the evidence being planted? Do they not want to see the evidence being planted? Or do they know the evidence is being planted and they are just in on it? Jane Gorham Mocker on Facebook, sending stars. Thank you so much. Appreciate it, Jane Gorham Mocker. And said, I want to see the shoes. I want to see the shoes. Now, I know that there was some discussion online, and I've seen it. I think it was early on. I don't know if that discussion is still going on, that they don't believe they're the same shoes. I recall from the last trial that I was investigating that issue, and from the images that I saw, it appeared they were the same shoes, but I'll wait to see it again. I mean, that shoe was very clear inside the courtroom today. The other one should be an exact match. Shoes come in pairs. Again, common sense. If the shoes aren't matched, right? If they're different, and what I recall from the first trial was I was not convinced that they were different. If they're different, that's evidence. That's really good evidence that something's being planted. If they're the same, okay, that's great evidence for the prosecution. Now the defense needs a little something more to get this jury to believe that it's reasonable to believe that someone would have planted it there. Becky Golombuski also sending stars. Thank you, Becky. Thank you, Becky. All right, over on Facebook. By the way, streaming live on my Facebook, YouTube, Twitch, and on X today. Great to have everyone aboard. All right. So right now, focusing on a couple of pieces. And here's Eve. Vinnie, are you colorblind? John was wearing shoes with white soles, not black soles. No. I remember going through this at the last trial and looking at various pictures and being convinced, not being convinced that they were different shoes. Not being convinced that they're different shoes. So we'll see what transpires during this trial. I'm just going by my recollection. And my recollection was there were photos taken, and that's something you have to understand. When you take a photo, like, photos could be very misleading. Video can be very misleading, depending upon the lighting, etc. Sometimes it's crystal clear. Sometimes it's not. I do recall looking at various pictures. I remember one picture did look like the soles were different colors, and then there was another picture where they didn't look like they were different colors. I think what should really happen is that both shoes should be brought into the courtroom for the jury to see. Right? That's the best way. I don't recall the defense hammering that point that they were different shoes. I don't recall that. They may have. I just don't recall them making that argument that they were different shoes. I've seen that online. All right. Here's something. And the plot twist pending. Vinnie. The McAlberts know this. They are cops, so it's easy for them to plant a shoe. Right. And that's what I'm saying. Well, you'd have to make that argument, and then you'd have to convince the jury that it's reasonable. There you go. Thank you, plot twist pending. But this is the dispositive issue. Because if a juror does not believe the evidence is planted and does not believe that it's a reasonable argument or reasonable explanation, then she's not going to be not guilty of everything. She may be guilty of something less than the top count, but if you don't believe this was planted, or you don't believe, well, it could have been, like, this is basically the analysis. I don't think it was planted, but I could see how maybe it was planted. Right there. That's where the defense needs to get the jury to. Like, well, yeah, it could have been planted. And if they get to that spot, then the defense has done their job. Again, because they don't have to prove that it was planted. They just have to prove that, well, could have been. Like, not like, yeah, sure, anything's possible. Men from Mars could have come down. No, it's more like, yeah, it could have been. Like it's not unreasonable to make that argument. And if they get the jury there, then you're in not guilty zone, because you need to be, because this issue is one way or the other. And if this issue goes the wrong way for the defense, Karen Reed will be convicted of something. No doubt. No doubt. Because there's no other explanation for her broken tail light to be next to John O'Keefe's body, or in the area of John O'Keefe's body in the snow. It's either planted or she hit him, period. Peppermint can think of 1,000 things that could have happened. Okay, Peppermint. And I love that your peppermint and your your icon, or whatever you want to call it here, your little circle thing here, is just white peppermint. That is classic. Well done. I can't think of 1,000 things that would happen that would leave her tail light there, other than it being planted. It doesn't accidentally get there. Someone has to plant it with the intent to frame Karen Reed, or she struck him. There's no other way. All right, one other way. He throws his glass and breaks her tail light. He breaks her tail light, but she doesn't strike him. And then after he breaks her tail light, then he goes in and something happens, and then they put him back out on the front yard. That just, that seems like that's more of a stretch. Is that a reasonable explanation for how it got there? John O'Keefe, slammed his glass against the taillight. The taillight imploded. But that's the best place for that evidence to come from is from Karen Reed. But she has never said that. She has never said that happened. She's driving. I think you would know, if you're driving, if someone would smash your taillight with a glass. But she's never said that, not in any of the media interviews, anywhere. It's never been part of the defense case. That's why things like that, to me, don't come into play. They don't come into play for a reason. Like, if that's what Karen Reed was saying from the beginning, John Smith threw his glass at my taillight. Boom. Okay, now it's in play. But she didn't say that. All right, still scrolling here, still scrolling. Sharon Leventhal. Snowplow driver saw Ford at the flagpole around 3:30 a.m. 29. Okay. How does that explain this tail light? This tail light still has to be planted there. Okay. And I know there's a lot of other facts here, but right now we're focusing on this piece of evidence, very specific piece of evidence that the jury was shown in court today. I'll show you another. I think I have another picture of it. A Ford at the flagpole, 330. Fine. But if the jury doesn't believe that this evidence was planted, then the Ford at the flagpole, 330, becomes irrelevant because her broken taillight is found there. It's her broken taillight. When it was broken, obviously, will be debated. But that's her broken taillight. Has to be planted. Has to be planted, period, end of story. Thank you, Sharon. I'm getting a lot of great comments and discussion. I don't think anyone is making it personal. It's like in The Godfather. Tell Michael, it wasn't personal. It's just business. This is the business I'm in. Let's see. And this is Monty Sliv. Kerry Roberts say he lived on Meadow, not lives in the 911 call with Sergeant Good. Interesting. Okay. Another good piece. Another good piece, another good argument you could make. However, question. Kerry Roberts, let me just question you on this. Like, Kerry Roberts isn't at the party. Kerry Roberts isn't part of this story until the following morning when she's woken up early in the morning. And then it's her, Jen McCabe, who she really didn't know beforehand, knows very well now. So at what point does Kerry Roberts become part of this, actively part of this? Was it Kerry Roberts in the 911 call? I thought that was Jennifer McCabe in the 911 call. It would make more sense if it was Jennifer McCabe. By the way, Cheryl Sabin Hobbs sending stars on Facebook. Thank you. Cheryl Sabin Hobbs. Okay. Thank you, Monty Sliv. But I do think it was Jennifer McCabe who made the 911 call, right? She was the one on the 911. So that would make more sense if she's saying lived, because according to the defense, she's in on it the night before. So that's much more consistent. But still, I bring you back to what I'm talking about today. The piece of evidence you're looking at needs to be planted. The jury needs to believe that that is a reasonable explanation for how it got there, because this is what they saw today. They saw those pieces. Now, something else they might be looking at with those pieces, are they sharp? Because those sharp pieces have caused the scratches. I don't know. I think that's one of the really rough facts in all of this. But at the end of the day, those are from her SUV. They are. When they were broken, where they were broken is an issue. But if they're broken on impact, the jury cannot vote not guilty on everything. Peppermint asking about my shirt today. No, my shirt is blank today. It's just a regular shirt. But of course, Peppermint is referencing all the great items that are available in my true crime merchandise shop, the Vinnie Originale store.
Hey everybody, I've got something for your body. Your body. You can wear it by yourself or with Frankie Valli. It's true crime merch from Vinnie Originale. It's true crime merch. It's true crime merch. It's true crime merch from Vinnie Originale. Vinnie original.
Yes, ladies and gentlemen, we got the True Crime merch is available. Great stuff that we've got for you. They'll post the links in the chat, or you can just go on Google or your search engine. Not Haas Long. No, you want to type in Vinnie Originale, and you should be able to find it. We've got the allegedly shirts, person of interest. We got the Tangent podcast stuff as well. So we got some cool stuff. All right. And Liv is with us. It's not personal, Sonny. It's strictly business. I think at that point, Sonny was gone already. Sonny had been taken out. At the end of the movie, Sonny's gone and Michael has assumed the lead of the family. And that's when they get Abe Vigoda, who became Fish on Barney Miller. And he's the one who set up the meeting. So they knew that he was the one who was the traitor. But it wasn't personal. He always liked Michael. And thank you, Liv. Appreciated. And Laura Dulaney, I believe Karen Reed was very jealous and insecure. It's obvious because of the voicemail she left that night, but I don't think she red-rummed him. Okay. So this is an interesting concept. Laura, you are right where some members of the jury were last time. None of them believed it was red rum. They were debating count 2, and they were debating a lesser charge in count 2. So the issue really was did she accidentally do it or did she not do it? Did she accidentally do it or did she not do it is really, I think, where this jury was at the end of the day. Because they also voted not guilty for leaving the scene of the accident, which you have to knowingly do. Like, to be guilty of leaving the scene of an accident, you have to know that you were in an accident. They didn't believe that she knew. So thank you, Laura. But as we continue looking at this evidence today, for that jury to believe not guilty, they need to believe that the stuff was planted. Now, this is an interesting part of that, and I think the defense made a pretty big deal in the first time around, is that in some of these evidence bags, there are fragments of fragments. So they may have written on the evidence bag. Do I have evidence bags here? I have some evidence bags here. I got Court TV evidence bags. How would you like to have one of these? How about this if you went to the supermarket? Oh, just put all my groceries in this bag for me, please. How cool is that? Oh, by the way, folks, any of you in the Boston area, next week doing the show live from up in Dedham. So Court TV is posting on their social media. I'll post it on my social media once I get theirs. We'll post a link to it. But they're posting a link where you can request to be in our live studio audience. And it's going to be an interactive studio audience. So if you have something to say, you'll likely have an opportunity to say it. We'll have our live guests there with us. And that's Monday through Friday of next week. Taking the shows on the road. Check over with Court TV social media. They're supposed to post a link where you can request to get on the list. It's like Studio 54. You got to be on the list. What's your name? No, you're not on the list. You're not on the list. No. Get on the list. Get on the list if you're up in the area, or make a trip to the area. See, that's the other great thing. And I've seen people do this in some of our big trials, is that people have traveled to the cities to go see the trials. The problem here, the courtroom is so small. If they had it in the real courtroom in that courthouse, the public would have been able to get in there to see. Now the seats are so limited that there's just no place to see. But you can be at the courthouse and then you can come check out our show live. It's going to be fun. It's going to be really fun. But anyway, so they place, now back to our regularly scheduled broadcast. So in the evidence bag, it might say, 2 pieces of tail light, and they start pulling it out. And what he's showing right now is a third piece of a tail light that was in there. And it seems what may have happened is that the taillight broke once taken into evidence. What the defense is going to argue that this is just a big problem. This is more of this sloppy investigation, that they're writing 2 pieces of taillight and there's 6 pieces inside there. Like, what is going on with all this, right? That's classic criminal defense mode that they're in. I put less credence in that than I do in some of the other issues that they're raising. But this is what we saw today as he pulled out a very small piece from inside the bag that was not part of the original 2 pieces of the taillight, which, is not a great look. But we've got plot twist pending is back. What do we have here? Agreed, Vinnie. Can the defense get the jury in their side without calling Proctor, since the Commonwealth doesn't seem like they are? Proctor's going to be on the witness stand one way or the other. If prosecutors don't call him, the defense will. The defense needs to. I don't know if, unless they get the evidence in against Proctor without calling Proctor, like his phone messages, etc., they might attempt to. I think it would be prosecutors don't need to call him to prove their case, right? Because they're getting this evidence in without him. But if they don't call him, the defense will use that against the prosecution and make them, prosecutors in this case, part of the conspiracy of hiding the truth of what really happened by hiding the lead investigator from you, ladies and gentlemen. So that's the danger of prosecutors not calling him, but they don't need him. So if you don't need him, why call him? You can cross-examine him. You can question him. The defense can call him. The defense can subpoena him and call him to the stand. They wouldn't be able to cross-examine him necessarily unless he was declared a hostile witness by the judge. Then you could ask leading questions. Otherwise, they'd have to ask open-ended questions, which is not exactly what you want to ask a witness like that. You want to be able to lead them where you want to take them. But if it's your witness, if you're the one calling the witness, you can't lead unless they're declared a hostile witness. I would like this witness declared a hostile witness, Your Honor. All right. Thank you so much. So can they can, but the strength of the defense case is showing Proctor to this jury live in court and today they set they sort of set the foundation for that by establishing through another witness that Proctor is the lead investigator in this case. No matter what prosecutors say, their own state trooper said, yeah, this was Proctor's case. So it's a really interesting strategic call by both sides here, how they deal with the Proctor issue. But we'll see how it goes. Here's Jessica Salty's plot twist. The leaf blower did it. And don't forget paper cups for collecting evidence. How did that get admitted anyway? I mean, the manner in which the evidence is gathered does not preclude the evidence from being admitted. What would preclude evidence from being admitted, physical pieces of evidence, are things like a chain of custody and authenticity, meaning the evidence wasn't authenticated. The chain of custody wasn't established. Those are the sort of things that keep pieces of evidence out of evidence, or if they are not relevant, right? That's how pieces of evidence don't come in. They aren't excluded because of the manner in which they were gathered at the scene. All that does is subject you to cross-examination and ridicule in front of the jury, which is what the defense did. But it's not going to keep it from evidence. To keep it from evidence, there needs to be a legal reason to keep it out of evidence. Not relevant, overly prejudicial, not probative, chain of custody was not established. the evidence was not authenticated. But they did all that. They did all that. So now this piece of evidence is one of the clear pieces of the tail light. And we always talk about the red tail light, but there's also the clear piece of the tail light that was gathered there. Again, it only gets there one way, two ways: impact or planted. And the jury got to see it. And those are pretty big pieces there. Pretty big pieces. So the jury's seeing the evidence. And that's who makes this decision. How do they figure out how it got there? Well, it's going to be based upon the surrounding evidence. So let's get to the tail light. Here's the way I've seen that it breaks down. Karen Reed's SUV is taken into custody at 4:16 in the afternoon and placed on a flatbed. It is then brought to the Canton PD Sallyport, where it's delivered at 5:30. The testimony is that the pieces of evidence are being found beginning at 5:45. So that's your window of time. For this evidence to be planted, you have arguably a little less than 15 minutes to break it, grab it, drive from the Canton PD over to 34 Fairview. It's not that far. It's just a few minutes away. And then plant the evidence. And the question is, with all the other people who were there already, the CERT team, et cetera, doing the search, are they in on it? Do they not? Are they oblivious to the evidence being planted, or do they turn a blind eye? It's got to be one of those three. Jury has to believe one of those three, that either they didn't see the evidence being planted, that they kind of knew what was going on, but they didn't want to see it, or they saw it and they're now part of the conspiracy and cover up as well. Jury has to believe that's reasonable. They have to believe that is reasonable. Otherwise, Karen Reed cannot be found not guilty of everything and just walk out of that courtroom. Because these are actual pieces from her taillight on her SUV that the jury has now seen were recovered at the scene. There's photographs of them in the snow. Then they're placed in the evidence bags by this man, Keefe, and then shown to the jury by this man, Keefe. Okay? So that's it. It's that simple, but it's that complicated all at the same time. But it's really it's a less than 15-minute window. It's a less than 15-minute window for this evidence to be planted. So I mentioned at the top, there are a few issues in this case that go one way or the other, okay? This is one of them. The evidence has to be planted for not guilty. Now, another way to get to an automatic not guilty is if there's evidence of John O'Keefe walking into the house. If the jury believes that he's in the house, then it's not guilty. It's game over. If the jury believes that Jennifer McCabe made that search at 2:27, it's not guilty. However, if the jury does not believe John O'Keefe ever made it into that house, the possibilities become much more limited as to what happened to John O'Keefe. The only thing outside of him getting struck by the car is him on his own, stumbling, falling, and whacking his head against the ground and dying accidentally. And then what you have is a situation with an accidental death on the front yard, followed by police framing Karen Reed for what happened to John O'Keefe, which was an actual accident. That's if he never gets in the house and Karen Reed doesn't strike him. They plant the evidence to make his accidental death look like red rum. To me, that's a little bit of a stretch too. To me, that's another stretch one. That's a stretch one. Because if he accidentally dies on his own, there's no reason for anyone to frame Karen Reed. Okay. Brennan, the human micropene. Is it reasonable that Lieutenant Leafblower didn't see the shoe in the morning light in 3 inches of snow? John also doesn't wear shoes in houses. Now, again, this is an argument you can make. But at the end of the day, the bottom line to all of these issues that you are discussing in this comment, and thank you so much, all come back to what I'm talking about, right? It's not reasonable that he didn't see it. He doesn't wear shoes in houses. That means it's reasonable to believe that he was framed. It's reasonable to believe that the evidence was planted. That's the ultimate conclusion here that the jury needs to come to. And it's those types of arguments and evidence that I think the defense is going to lean on to try to get the jury there. Because there's no video, there's no testimony of anyone talking about someone planting evidence. The closest you have to video evidence of something is the Sallyport video where Trooper Proctor is seen standing near the broken taillight. That's the opportunity that the defense will argue about. That was his opportunity to grab those pieces, get out of the Sallyport, and either give the pieces to someone else or do it himself and go from the Sallyport at Canton PD to 34 Fairview and start planting these pieces of the tail light. That's the closest you have from the defense perspective of any video evidence of this. Otherwise, you are going to need to really build arguments like this. Like, really, ladies and gentlemen, is it reasonable that Lieutenant Leafblower didn't see that shoe in 3 inches of snow? Now, I think what prosecutors will say about the 3 inches of snow is that it's not really 3 inches of snow because of where it is at the curb. So if the snow plows are coming by, any of you who've lived in the Northeast or wherever you get snow, Midwest, you know, when the snow plow comes by and plows the street, the snow gets pushed somewhere. It gets pushed to the side of the road. So you always have a buildup of snow piles. And it's annoying sometimes because a lot of times they'll push it right in front of your driveway. So not only do you have to shovel your driveway, then you got to shovel all the packed snow from the snow plows that have come down your street to clean the street, but they keep the plow on an angle and they push it to the side and it ends up piled up, in front of your driveway and up against the curb. That's what I believe prosecutors will argue about, that not being just the light 3 inches of snow. Now, that's Lieutenant Leafblower, who is not exactly where the shoe is found. He's blowing the leaves closer to the flagpole, closer to where John O'Keefe was found. But again, with all that, good arguments, good issues, that's Brennan, what needs to be argued by the defense to get the jury to the place of saying, oh yeah, somebody could have planted it. He didn't see it. He didn't see it. He didn't see it. So, probably wasn't there. Wasn't there until someone planted it. I would argue, though, with the shoe, like where'd the shoe come from? If it's planted later in the day, who planted it, when, and who was keeping the shoe? Is it Brian Albert? The shoe was inside and then he puts it outside later in the day? I don't know. Thank you, Brennan. All right. I'm almost out of time here. So I get ready for the show. 6 to 8 tonight, folks. 6 to 8 tonight. Obviously, 2 hours. We will be talking about this case. Here's a Gitmo Holiday. This is another issue people have talked about, the pieces of taillight that are found on the clothes. Gitmo Holiday pointing out that these particles were found by Proctor and delivered separate from the clothes, which becomes a problem. You need someone other than Proctor finding this stuff. All right, let's see who else. Oh. Let me see. And Madman in a Box says John O'Keefe did wear shoes in people's houses. That's interesting, right? You're in Massachusetts. For me, shoes in the house, it depends. It depends on the weather. It depends on the homeowner. It depends on the issues of carpet versus like hardwood floors or tile. Hardwood or tile, not taking my shoes off. If you've got that wall-to-wall carpet, all right. I got to make sure I'm not the one messing up your carpet. Anywho, thank you so much. Great comments, great discussion. 8 o'clock tonight, Court TV. We'll be dealing with everything that happened today in the 8 o'clock hour. Then in 9 o'clock, we're going to zoom in, and we've been doing this in the second hour, doing a deeper dive on issues connected to the case. Trying to uncover a little bit more of what's going on in the case. And we're going to specifically zoom in on Brian Albert and Brian Higgins tonight. And not just kind of say, oh, yeah, they're saying that Higgins, that. No. We're really going to look at, what their connections are to all of this and what behavior is arguably suspicious. So that's at 9 o'clock tonight. Make sure you're watching. Zuko, I don't know if you can hear him. I don't know if you can hear Zuko in the background, but he's all, he can't stop watching this thing either. It's crazy. All right, Zuko, we've got geese that have been showing up and he's been going nuts. Anyhow, so let's do this. We're at the end of this show here. Oh, by the way, Gen X reminding us that Zuko's amped up.
Order in the chat. Order in the chat. Don't dare attack. We've got order in this chat. The Mod Squad is on the job, helping us to keep it clean. The Mod Squad is on the job, always so nice and never mean. So let's give it up.
All right, folks. Big thank you to Gen X, Frankie Figs, Jennifer Sube, Ashley Bouchard, our Mod Squad doing a great job. And it's not an easy job when it comes to this case because you know how you get people. You know how you get in there. I get those direct messages. I know how you are. All right. All right. We're going to do the blood sugar. So I'm a type 1 diabetic. I actually went to my endocrinologist today. So that's always a fun day. So my blood sugar, I'll do it here. It was just a normal day today. Nothing crazy other than, where is it? They took my blood. Look at this. Look at this. Should I uncover it or is it too gruesome? I'm the diabetic who hates needles. All right. So it's time to guess my blood sugar.
Here's a type 1. He's type 1. His pancreas is on fruits. He has diabetes, type 1 juvenile diabetes. And so it's time to guess, is more or less. What's his blood sugar? What's Vinnie's blood sugar? Under 70, he gets life's head. Under 60, all the alarms start ringing. Over 180, he starts to get lethargic. But when it's 90, Vinnie, eyes are singing. And so it's time to guess, is it more or less? What's his blood sugar? What's Vinnie's blood sugar?
Very close, Jennifer.
But take a guess. Yes, take a guess. Let's guess Vinnie's blood sugar now.
Looks like we have to run it. We have to run it back. Peppermint 1 million.
Here's the type 1. Here's type 1. His pancreas is on fruits. He has diabetes, type 1 juvenile diabetes. And so it's time to guess, is it more or less? What's his blood sugar? What's Vinnie's blood sugar? Under 70, he gets life's head. Under 60, all the alarms start ringing.
All right. Congratulations to Ginny from NYC. Getting it correct today. I gotta mark you down in my little book here. I keep track of this stuff, because you can win a lovely prize. All right. At the end of each quarter, the one who guesses it correctly the most goes shopping in the Vinnie Originale store. So, Ginny, congratulations with your 109 here on the 7th of May. So, what do we go? April, May, June. Yeah, at the end of June, we'll have another winner. End of June. We haven't done it enough because I've been so busy. All right. Thank you, Ginny. We had a lot of good guesses out there, and that's it. So I'll see you 8 o'clock tonight on Court TV, 8 o'clock to 9 o'clock, closing arguments, 9 o'clock to 10 o'clock, Vinnie Politan investigates. Awesome job. Great to see y'all. Last week, how you doing won last week. How you doing had 135 last week. How you doing? You got it correct. Great to see everyone. Have a great night. And as always, please don't forget. One second. Where is it? Oh, here we go. To hug the kids.
Say goodbye. Thank you for watching Vinnie live. We'll be back, but I don't know when. We hope that you will watch again. Vinnie live. It's Vinnie live. Whoa, it's Vinnie live. To our awesome mosh. Thank you for those super chats. Please hit the like and do subscribe. Let's do it again on Vinnie Live. Now before you go, just one more thing. Please post below. Before you go, just one more thing. Please post below. Say anything.